Hello, my name's David Winch and I'm a forensic accountant with Barfield's Forensic Accountants. And today we're going to spend about 30 minutes talking about criminal legal aid, trying to cover some useful points. So, the agenda. I'll tell you about the scope of the session, a brief comment on why have criminal legal aid exist at all, and then a couple of slides on legal aid and expert witnesses, which of course is of particular interest to me because I'm a forensic accountant expert witness in criminal proceedings. Then I'm going to talk about income contributions under legal aid, which are a little bit complex. Then talk about capital contribution. And then finally, a short session on the impact of legal aid contributions on the defendant's available amount in subsequent confiscation proceedings if he's been convicted. And my usual roundup of how Barfield's Forensic Accountants can help you and how to get in touch if you need some assistance. Okay, so let's kick off. Today, I'm going to be considering legal aid in relation to criminal trials and related confiscation proceedings in the Crown Court in England and Wales. So I'm not going to be talking about magistrates' court criminal aid, criminal legal aid, or indeed civil legal aid in family or whatever. Because we've only got 30 minutes or so, I'm only going to deal in outline with some of these matters. I'm not going to be able to do worked examples and things like that. But as I say, if you need some more help, do get in touch with me. The email address is on the final slide. Okay, so why should we have criminal legal aid? Well, we all know that criminal legal aid gets a bad press. We see these headlines of somebody who's done a murder or some other dastardly crime being given £1 million in legal aid or whatever. And of course, any lawyer will know that the defendant is not in any sense given £1 million or any amount of money. What does happen is that some of his legal costs are funded through legal aid. And ultimately, as we shall see later, he may have to pay that money back. Let's just imagine, though, that if there was no legal aid, if the majority of defendants in criminal proceedings in the Crown Court represented themselves, it would be chaos. The defence lawyers, amongst other things, do help to educate their client as to what points can be made and what points can't be made and what should be pursued and what it would be hopeless to pursue. And I have this horrible vision of defendants representing themselves in the Crown Court bellowing objection from the dock or something like that because they've been watching American TV. It would just be a disaster. So we really do need, to help the courts function, we need defence lawyers to assist defendants. And of course, if there was no criminal legal aid, then only the very wealthy would be able to afford lawyers, and that simply wouldn't be fair. So criminal legal aid supports the principle of equality of arms and supports the administration of justice in England and Wales. We couldn't do without it. The remuneration legislation is the key item, I suppose, is the Criminal Legal Aid Remuneration Regulations 2013, as subsequently amended, and they have been amended quite a bit. There have been numerous amendments over the years. That in turn, those regulations rest on the Legal Aid and Sentencing Act that came before. Let's look at legal aid and expert witnesses because, as I say, that's the interest for me as an expert witness forensic accountant. So in relation to those regulations that I just mentioned, Regulation 16 and Schedule 5 are of particular interest. That says that you can get funding for an expert witness, and it gives rates of funding, and the rates that are in Schedule 5 as amended were cut by 20% in December 2013, and they've not changed since. If you consider that the rates when the statutory instrument was brought in earlier in 2013 were not generous, they were then cut by 20% across the board, and they have stayed at that level ever since. So that's what, getting on for 8 years now. There's been no inflation uplift at all. And I appreciate that lawyers are by no means handsomely paid in criminal legal aid. Experts are not either. Most of the rates in Schedule 5 are hourly rates. And in relation to some types of expert, the rates in London differ from those outside London. Sometimes they're higher, sometimes they're lower. As far as accountants are concerned, actually the rates are the same in London and outside London. What is a little bit unusual with accountants is that there are different rates prescribed for each level of staff in an accountant's firm. So if you've got an expert witness, such as myself, who's going to turn up and actually go in the witness box and give all evidence, actually sign a written report, then there's a rate for me, and there's a lower rate for analysts and so on who work in support of me, and so on. Prior authority can, and I would suggest it usually should, be obtained for the expected cost of an expert witness. And one of the reasons why prior authority should be obtained is that if you get the authority of the legal aid agency in advance, then you know that you're going to be able to pay the expert when you get his bill. And from the point of view of the expert, obviously, I look for prior authority to be obtained before I undertake work, if it possibly can be. That, again, can be a bit of a process, because the legal aid agency might ask for competing quotes from other forensic accountants, and invariably they will choose the cheapest, who may not be the person who's done the most comprehensive quotes, and so on. So it is a little bit difficult, but it's a procedure which I think we have to go through. And the online forms for applying for prior authority can be a little tricky as well, particularly as I've said, where we've got different rates for different levels of staff within the accountant's practice. It is possible to do that on the online forms. It's not easy. And then when you've got that prior authority, the expert's fees can be claimed from the legal aid agency as soon as you get the bill. You don't have to wait for the court proceedings to finish, or even for the court proceedings to commence. You can make a claim for what's called an interim payment of disbursements under Regulation 14, and then you can pay your expert for his work once he's completed it and billed it to you. And again, from my point of view, obviously, I would rather get paid when I send the bill in, rather than have to wait months or even years for things to get to court and get finalised. Okay, that's really all I want to say about legal aid remuneration, because the main focus today is going to be on legal aid contributions. The legal aid contribution legislation is in a separate statutory instrument, the Criminal Legal Aid Contribution Orders Regulations 2013, and again, there have been amendments to that since. Let's talk about income contributions first. The first thing to say is that a defendant is not liable to make any income or capital contribution if he is in receipt of a state benefit which is specified in Regulation 9. And one of those, and perhaps the most common one today, is universal credit. So if you've got a defendant who you're supporting under legal aid and he's in receipt of universal credit, that's the end of it as far as contributions are concerned. He's not going to be required to make any contributions. And the next 20 minutes you can, of my chat, you can ignore because none of it is going to be of any relevance to a defendant who's receiving universal credit or one of the other benefits that is listed in Regulation 9. So that's simple and that's straightforward. Now let's consider the defendant who is not in receipt of one of those benefits. Where are we as far as he's concerned? Right, a little bit more complex. If the defendant is not in receipt of one of those benefits, so that he may be liable to make a contribution, then we need to calculate his gross annual income under Regulation 10. And if his gross annual income does not exceed £12,475, which, as you will appreciate, is not much, he is not liable to make any income contribution. But as we'll see later, he might be liable to make a capital contribution. Right, so does that mean that if his gross annual income does exceed 12,475, he must make an income contribution? No, it doesn't. It's a bit more complicated. If his income exceeds 12,475, then we move on to the next step. And the next step is that we make a calculation, of his disposable annual income under Regulation 11. So what is his disposable annual income? Well, his disposable annual income is his gross annual income less certain specified items. And one of those items is an amount to represent his cost of living expenses. And you won't be surprised to hear that that is not a generous allowance. And then if the defendant's disposable annual income does not exceed £3,398, he's not liable to make an income contribution. Now, as you appreciate, an annual income, an annual disposable income of just under £3,400 is not huge. But if his disposable income is below that figure, and there's one or two twists which I'll mention later as to how you calculate this. If it's below that figure of 3,398, then he's not liable to make an income contribution. But you may still have to consider, indeed you will still have to consider later on whether he's liable to make a capital contribution. Because the two computations of income contributions and capital contributions are quite separate and different. So if the defendant's disposable annual income does exceed 3,398, then he is liable to make income contributions. And what are those income contributions going to be? Well, the income contributions will be not more than 6 monthly payments. Could be 5, could be 6 monthly payments, each of which is 90% of 1/12 of his disposable annual income. So in effect, what we're saying is each month you look at 1/12 of his annual income, fair enough, and 1/12 of his disposable annual income, and he's liable to pay 90% of that, which is quite a substantial contribution. There is an overriding maximum which relates to the type of offence of which he is being charged. So, for example, if he's being charged with dishonesty, say a theft of £150,000, then the overriding maximum is higher than if he's being charged with, say, a theft of £1,500. And there's a table of these in the regulations. So the total of his income contributions will be not more than 45% of his disposable annual income. And once he has made the 5 or 6 monthly payments, the income contributions cease. So if his trial is delayed and so on, he doesn't carry on paying more and more monthly income contributions until he gets to trial. He pays no more than 6 monthly payments. Now, a couple of things here. One is that when we talk about the defendant's income is defined in the regulations to include the income of himself and his spouse or civil partner or cohabitee. So in a sense, you might call it the household income. It's not called the household income in the regulations, but in effect, that's what it is. So if you've got a husband and wife and they're both earning, then his income is the income of the pair of them combined. And in calculating the income, you do then make a reduction, a proportionate reduction for the number of people in the household. Again, there's a table of these reductions. If you've got, say, a husband and wife, then you divide the total by 1.64 to work out the income. Why is it 1.64? Because that's what it says in the regulations. And there are different adjustments to be made for children of different ages and so on. All the details are spelled out in the regulations as to how you make that adjustment. I should mention that where the defendant's disposable annual income exceeds £37,500, he will normally not be eligible for legal aid in relation to a Crown Court trial. So obviously, if he's not eligible for legal aid in relation to the Crown Court trial, then he won't be making income contributions and he won't be making capital contributions because he won't be getting any legal aid. Okay. Where, as things turn out, the income contributions which the defendant has paid prior to his trial exceed the legal aid costs actually incurred in terms of solicitors, barristers, expert witnesses, and so on, in getting the thing there to trial and getting the trial completed, then the defendant is entitled to a refund of the excess. In other words, he's not going to pay in contributions more than the legal aid agency have paid out to solicitors, barristers, expert witnesses, and so on. And if he's acquitted of all the charges, then his income contributions will be refunded to him. So in effect, he's back to square one. He's got legal aid to cover all his legal costs. He goes to court, he's acquitted, he gets all the money back. Happiness. If he's charged with more than one offence and he's acquitted of some charges and convicted of some charges, then he may be entitled to a partial refund. What happens is that his lawyers have to make an application to the court. I think it's within 21 days of his conviction, have to make an application to the court for the judge to set a proportion of the legal expenses which related to, if you like, to the convictions, and a proportion which relate to the acquittals, and then there's a reduction in respect of the acquittals. But that application has to be made quite promptly after conviction. Income, by the way, should be calculated based on the period of 1 year ending on the date when the application for legal aid was made. In practice, again, because of delays and so on, it may be that the defendant's income position changes between making the application and the thing getting to court. And it is then possible to make an application for the calculation to be revisited in the hopes of getting a reduction in contributions. don't forget that the defendant is obliged to provide documentary evidence of income in support of his application for legal aid. Okay, hopefully that's given us some sort of idea about income contributions. What about capital contribution? First thing to remember is a defendant may be liable to make a capital contribution even where he was not liable to make an income contribution. So if we've got, say, a defendant who has very little income, but owns the house in which he lives, that house will be part of his capital. He may find himself paying no income contribution, but paying a chunky capital contribution. Defendant is not liable to make any income or capital contributions, as we said, if he's in receipt of one of those state benefits specified in Regulation 9. And where the recoverable costs of the representation are less than the amount he has already paid in income contributions, then sensibly there's not going to be a capital contribution because he's already paid it. He's already covered it. But in other cases, a calculation is going to need to be made of the defendant's capital on the date when the application for legal aid is made. Then what we do is we take a fixed deduction of £30,000 from the defendant's capital to arrive at what's called the defendant's disposable specified capital. Now, I say we make a fixed deduction of £30,000. We do, unless, if you like, as a sort of sanction for failing to supply required documentary evidence, that 30,000 deduction is not made. So where the defendant has provided all the information, all the documents concerning his capital, there's going to be a fixed deduction of £30,000 from his capital to calculate this figure of the disposable specified capital. And useful to remember, assets subject to a restraint order are excluded from disposable specified capital. So if you've got a situation where there's potential for confiscation proceedings and the prosecution have obtained a restraint order covering the defendant's assets, then those are going to be excluded from his capital calculation, from his disposable specified capital. And then his capital contribution is the lower of the amount of the recoverable costs of representation, the amount that's been paid to his solicitors and barristers, expert witnesses and so on, less what he's already paid or what is outstanding under income contributions. So in other words, the top up to cover the total cost of his representation that's going to be covered by income contributions he's already made or is due to make, plus a capital contribution. Or if lower, the amount of his disposable specified capital. So in other words, his capital contribution cannot exceed his capital, and his capital for this purpose, his disposable capital, is calculated to leave him with 30,000. But remember, in these calculations, the defendant's capital, much like the income, includes that of his spouse, civil partner, or cohabitee. So that if you've got, say, husband and wife owning a house together, then the whole of the value of that house is going to be falling into his contribution, his calculation of capital. And as I've already mentioned, the defendant is obliged to provide documentary evidence of capital in support of his application for legal aid. And similar to what we were saying with income contributions, the defendant who's acquitted of some of the charges and convicted of some can apply to the court for this allocation of a proportion of his representation to be recoverable relating to the convictions. Obviously, if he is acquitted of all the charges, then the question of capital contributions will never arise. Where the defendant fails to pay a legal aid contribution, the Lord Chancellor may charge interest and enforce payment through the courts, for example, by a charging order on the defendant's home. Okay, so that's covered capital contributions. The interesting thing, of course, is that the income contributions arise before trial. And so we won't know at that stage, obviously, whether the defendant's going to be convicted or acquitted. The capital contribution is after trial. So if he's acquitted, he's not going to be paying a capital contribution. If he's acquitted of all the offences, if he's convicted, then that's different. Do remember, as I've mentioned, where the defendant's financial circumstances have changed since the time the legal aid application is made, it may be possible to have the contributions recalculated. Okay, I deal a lot with confiscation, and I'm very often instructed under legal aid arrangements as well. So what is the impact on a defendant's available amount in confiscation of his legal aid contributions? Well, let's look at that quickly. Generally, in confiscation proceedings, liabilities for legal aid contributions are not taken into account in calculating the defendant's available amount. You'll remember that in confiscation, when we're looking at available amount, we do take off secured liabilities like mortgages, but we don't take any account of things like bank overdrafts, credit card debts, general unpaid bills. So a legal aid contribution isn't a secured liability, whether it's an income contribution or a capital contribution. It's not secured. So generally, it will simply be ignored in calculating the defendant's available amount. Of course, if those contributions have actually been paid before the date on which the confiscation order is made, then the defendant hasn't got that money because he's used it to pay the bills. And because he hasn't got that money, then his available amount is less than it would be, obviously, if he still had the money. So there might be something to be said for paying his legal aid contributions, if he has to, before the confiscation order is calculated, and then arguing that because he no longer has those funds, they shouldn't be part of his available amount. Of course, he won't be able to do that if he's subject to a restraint order. But then, as we've said, if the assets are subject to restraint, they shouldn't be taken into account in calculating his capital contributions. But let's just remember as well, when we're calculating a defendant's available amount, this is generally based on his own assets or her own assets, if the defendant's female, his or her own assets plus any tainted gifts. So if we go back to the situation of the husband and wife who own a house between them, and maybe they've got 50% interest in the equity each of them, then if, let's say, the husband has been convicted of an offence and is subject to confiscation, then in calculating his available amount, we will take into account his 50% of the equity in the house. Whereas in calculating capital contributions, we're taking into account his and her interest in the equity in the house. So there is a difference of approach there between the capital contributions analysis and the available amount. And that could have an impact on how things work out. So it could be, for example, that you've got a defendant who is absolutely cleaned out by a confiscation order. his benefit exceeds his available amount, and he's ordered to pay the whole of his available amount, including, let's say, 50% of the equity in his home. Does that mean he's not going to be liable to a capital contribution under legal aid? No, it doesn't, because his wife still has the other 50% of equity in the house, and that is part of his disposable capital in terms of the legal aid contribution. So he may find himself not only cleaned out by a confiscation order, but also, in effect, his wife having to pay, having to meet the capital contribution under a legal aid contribution order. Okay, that was a quick run through of legal aid as it relates to experts and as it relates to income and capital contributions. Do remember that Bartfield's Forensic Accountants is part of the Sedulo family of companies, which offer a full range of financial services for businesses and individuals. And we undertake legally aided and privately funded criminal and civil forensic accountancy work. We have a team of experienced and highly trained forensic accountants, analysts and support staff using the latest IT facilities. And we operate from offices in Leeds, Manchester, Liverpool and London. You can find more on this topic and other topics on our website in the blog, which is in the Insights area. And this and previous webinars can be found in the seminars section of the same website. The links are on the screen. We will send you a recording of this webinar by email, a link to it. And I promised you my contact details. Here they are. Give me an email if you've got any queries, anything I can help you with. Email is much better than phone because, frankly, if you phone, you'll probably find I'm not in the office when you want to speak to me. And if you do get me, I'll say, well, I can't really answer that without having a think about it and I'll look at some documents, so send me an email. So email address is there. Thank you very much for your time, and I look forward to seeing you again very soon. Thank you. Bye for now.